Well, good morning and good afternoon, everyone. We're so delighted you're here to join us in our presentation this afternoon, titled Choppy Waters, Navigating Increased Scrutiny and Legal Liability for CISOs. I'm Tom Skura. I'm part of the Cyber Risk Collaborative in charge of S&B program development. I'm introducing Dr. Dustin Sachs, who's a CISSP, our Chief Technologist and Senior Director of Programs who leads our program development. And Dustin will be joining us with our guest presenter, Stephen Tepler, Esquire, Chief Cybersecurity Legal Officer from Manivong Barrett and PC. Just a few housekeeping rules here. Please put your questions in the Q&A and we will get to them during and after the presentations. These slides are available to everyone. At the end, we will give you the name of Tom Ward and his email, and he will provide you with the slides. Steve's contact information will be in these slides as well. So let me just kind of introduce Steve and say, we're so delighted you're here. He was recommended by one of our members as someone in the legal profession who can offer some good legal perspectives on CISO liability and ways the CISOs can manage those concerns. He's instructed me as a lawyer that this is not legal advice, this is guidance for your information. So thank you, Steve, for keeping that foremost on our minds. As I mentioned, he's Manivong Barrett's Chief Cybersecurity Legal Officer. He leads the firm's cybersecurity and privacy practice. He focuses practice on proactive, preventive, and remedial cybersecurity and privacy work for clients and advises clients on potential class action, mass tort liability arising from security vulnerabilities and code defects in technology-enabled devices and services. Steve is a founding co-chair of the Standing Committee of the Cybersecurity and Privacy Law of the Florida Bar, and he also teaches cybersecurity law at Nova Southeastern University Shepherd Broad School of Law. So welcome, Stephen. Appreciate you being here.
Thank you. Thank you for having me.
So I just want to remind everyone that this is sponsored by the Cyber Risk Collaborative as part of the broader Cyber Risk Alliance. And we offer for members an accelerator program creating value for cybersecurity leaders and their teams. When you join our community, you have the ability to ask the experts through a rapid response process. So if you have immediate concern about an incident or anywhere in your organization, we bring members together to support you in that regard. We do have task forces specifically dedicated to different security topics. We had one recently on the SEC regulations, which I'll go into a little bit. And again, we invite CISOs and their staffs to collaborate on their challenges and best practices. We share them, we publish tools and guidance documents out of that. We provide strategic threat intelligence to our members. One key thing that you get by joining every morning is a morning security report that apprises you of major security events, key vulnerabilities, and threats. It comes out at 6:30 Eastern in the morning, so you're always informed before going into your office or meeting with your management, who may ask you questions about what is going on in the cyber world. We have CISO developed tools and templates, which I'll share at the end of the presentation. And also we engage in personal brand development and leadership opportunities to improve CISO and staff leadership capabilities within their organizations. So this all came about from a SEC cybersecurity regulation and CISO liability task force, as you can see, attended by a large number of esteemed organizations. They met representing different industries and government agencies. And the SEC regulation posed a lot of challenges for organizations in terms of how to report incidents on my 8K. How do I inform the world about my cybersecurity program on the 10K? And we met and actually created a guidance document, as you can see by the contents, that provide members with guidance on how they should respond to the 10K. We show actual examples and also how to respond to 10Ks. But we also talked about CISO liability. We had that as one of our main aspects of what we were doing. And how could the CISO protect him or herself? So we're going to share some of the key things that came out of this task force, but then Steve is going to talk more about how legal guidance from an external perspective can actually help the CISO and protect the organization, and what you can benefit from having that guidance. What we learned in our task forces, obviously, is don't ever lie to a regulator, criminal investigator. We know that there have been a number of CISOs that have been charged with fraud in the case of SolarWinds and Uber. It's something we know we shouldn't do, but oftentimes the CISO is pressured by the internal organization to maybe not communicate fully what happened, proactively tell the whole truth to management and legal department about the details and impact and root causes of an incident. Now, we'll certainly want to hear from Stephen about his perspectives on that. But again, the CISO has to be truthful and talk to the right individuals within his or her organization. Establish an openly communicative relationship with legal counsel. Keep the details of and records associated with an incident, including email communications. Remember, it said, hey, you've got to protect yourself. So you might have incident records, but maintaining a personal diary or notes may be valuable in that regard. And again, get appropriate coverage under the company's D&O insurance policy. And again, the information on the right of the slide, which will be available to you, kind of tells you what you need to look for. And this is if you're an existing CISO, and clearly if you're moving on to an organization, these are some of the things that the CISO should be concerned about. So with that, I'm going to turn over our discussion and presentation. Again, please put your questions in the Q&A, and Dustin's going to help us look at these and bring them up as Steve goes through the presentation. But Steve, again, delighted to have you here from the legal perspective of outside counsel. We're looking forward to your advice and guidance, and I'll turn it over to you.
Okay. All right. So, you're the CISO. Congratulations. You're the front line of digital defense. Let's parse that a little bit and see what happens. Next slide, please. So what about you? You are personally, let's see where you wind up in the spectrum of liability. Please go to the next slide. Actually, ChatGPT made a pretty decent slide on this, but that pretty much doesn't need a title, does it? This is more often the case than not, and it is becoming an increasing concern among CISOs. And part of the reason why my practice has been developing to focus on CISOs' needs and protecting CISOs, because in protecting the organization and protecting the CISO, you can protect the organization. And I'll go into this a little bit more, but let's go into some context first. And let's move to the next slide. So you're in the firing line, more so than the front line, because you are basically, taking fire from all sides, both internal and external. So you heard about the role of the Chief Information Security Officer is more crucial than ever. The more crucial it gets, perhaps your authority does not scale up with the cruciality of your role. Your level of reporting perhaps doesn't increase with the increased cruciality of your role. You're the architects behind strategies that protects the organization's most valuable digital assets. Before we began this, in our prep for this and doing a sound check, we were talking about where CISOs lie on the chessboard. And boy, oh boy, is there a diverse opinion on that. Anywhere between a rook and a king, but we can talk about that a little bit later. So basically, your threats are evolving all the time. They get worse and worse. Threat actors are always ahead of the game, and in my practice, I have become, I guess, more. I wouldn't call it xenophobic, but we're under attack. We're at war. There's no two ways about it. I hear stories all the way from large organizations to single individuals who basically are being funding activities that operate against our nation's best interests. And whichever side of the political coin you're on, it really doesn't matter. It's aimed at undermining the foundational principles of our democracy. And it's my personal opinion. Other people may disagree, but the expectations placed on CISOs, given this heightened global threat, becomes increasingly burdensome, and the risk on the CISOs, as well as the organizations, increase, and so does the target on your back. And let's move on to the next slide. So the position of CISOs are tenuous, as you all know. This is no mystery. I think the average tenure of a CISO is about 2.5 years. The old joke, and it's not a joke, used to be, well, CISO started work at a company, realized that things were becoming untenable, and would try to leave before the fecal matter hit the fan, so that they couldn't be blamed for it. And that's pretty much not as much the case anymore. I don't think you can cut away as easily as possible, especially since regulators are looking at what happened during your tenure. And this is where the problem begins, because if what happens during your tenure can be attributed to you in some way, it's going to bring you into the line of fire. And of course, when stuff does happen, if you're watching this, you know that the fingers are pointing in every direction, but the people or the areas that are really accountable for that. So now there are legal and regulatory repercussions, even with the new SEC regulations, which pretty much are, if you looked at them and said, gee, this is what we're supposed to be doing anyway, whether we're a public company or at this point, I would not be surprised that if you do business with a public company, that the public company will require you or your organization as well to be compliant, or to indemnify, or to make warranties and representations, or to demonstrate in some way that your level of security and reporting, cybersecurity and reporting, coordinates with theirs to the extent that the public company will be satisfied. It's almost similar to being a business associate for HIPAA, where you have to have the same, because you control or you process the information of another entity, that you're required to have the same and demonstrate the same level of cybersecurity, including having risk assessments and your tabletops and your appropriate policies and procedures all in place, and being able to demonstrate that on a periodic basis. So, the role of a CISO becomes precarious. You're balancing between effective security measure implementation, navigating the aftermath of breaches, worrying about getting resourcing for it, and worrying even more about what happens when you either don't get the resourcing for it, or when the organization is not responsive to what you are telling them, reporting to them as a problem. And this is where this is kind of where I come in a legal manner, and we'll talk about that. In fact, I think I'm just going to start this on the next slide. So let's do that.
Stephen, may
Yes.
I just interrupt you
Please.
with a couple of questions from the audience that I think are important to bring up here. I'm going to concatenate the two of them because they're related. The first question comes in from Eric. Many companies don't have a dedicated CISO in those situations who is a CISO, and Todd has also embellished on that. Some people have noted that Tim B was not the CISO at the time of the SolarWinds attack, but he was the senior most security guy at the company. Most frameworks regs don't call out CISO title, but do ask who's responsible. Does the title matter? If you don't have a CISO, is someone else named, is targeted, I guess, in that sense?
In the first instance, I think it's role-based more than anything else, rose by any other name. But if you are call the CISO and you're not given the appropriate authority and reporting responsibilities of a CISO, because you're not quote unquote C-level, and we'll talk about what does C-level mean for a chief information security officer. It's usually just a tag that you're given. You don't report to the board, you don't report to the president, you report to a CIO. And as lovely a position as a CIO means, CIOs want a business to run and run properly. If a CISO reports to a CIO, the CISO's position is almost immediately not compromised so much as limited, because you have to filter through someone who wants to get business done versus filtering to the ultimate responsibility to the enterprise for problems, for cybersecurity problems. And that's critical to understand. And whether it's reflected in pay or not, be careful when you get called the CISO. You pretty much be careful what you ask for. But if you get that denomination, that title, make sure that you get the attendant authority and privilege and reporting responsibilities, as well as the responsibilities of the position. So the short answer is, it doesn't matter what you're called. The fickle finger of fate will gravitate to you if you are adopting the roles and the tasks of a CISO.
Good. And just to follow on that,
Sure.
as Gary was saying, CIOs have a challenge with IT and cyber from the separation of duties perspective, unquestionably, especially when it comes to budgeting, and prioritizing projects. Definitely wanted to call that out.
So I'll give you an example from my experience, and I'm going to try and inject as much anonymized experiential input as I can into this. Mm-hmm. I represent a very large organization that generates about $3 billion a year. I'm their outside cyber counsel. This is not breach counsel. It's not remediation counsel. It's my job is to work with the CISO in making sure, in preparing the organization to understand what its risk profile is, doing the risk analysis, doing the assessment, doing the policy review, doing whatever. All this is nothing new to anybody who's attending this. But where I come in, and especially for this organization, the CISO was having a problem being listened to. Knowledgeable person, knew what he wanted, and security was all over the place. And at one point, we had a lot of heart-to-heart conversations. And remember, I represent the organization, but I can't represent the organization properly unless the CISO and I are aligned perfectly, right? And he was explaining to me what was problem. It might have been with multi-factor authentication. We'll talk about insurance and MFA in a bit. It was about one of the security gaps that they had. And if any of you have New Yorkers as clients or employees for that matter, there's a general business law 899 BB, which requires that you must have appropriate controls, technical, administrative, and physical controls in order to demonstrate reasonable security, blah, blah, blah. But the state attorney general has come after a variety of companies, including law firms, for failure to do that, even in the absence of a data incident, of a cybersecurity incident. So we identified this gap, and the budget for cybersecurity was woefully inefficient. And I had so I told the CISO, you write the memo, you put it in your files. I'm counsel for the company. I'm going to write them a memo as well and say, look, if you don't address this, you are likely in violation of this. And in coordination with the CISO has confirmed this with me. I just want to let you know this. And put it into more legal language. What did I do? What did I effectuate by doing this? Number one, I covered the CISO. okay, because it was a genuine concern. I also covered myself because I don't want to be thrown under the bus as cyber legal counsel. But what this did was it moved the company to increase their funding from $1 million to $4 million.
So
Right?
that's a really advantage to having you as an external party to,
Yeah,
you know,
me or
to
someone like
increase
me.
resources. Yeah,
Me or someone like me.
exactly.
This is, there aren't a lot of people who do what I do because most of, your cybersecurity lawyers tend to come from either IP or litigation. And I have a little bit of IP and a lot of litigation experience, but my litigation experience is mostly on the plaintiff side. So when I do my risk assessments, I come in and I tell the client how I would sue them. And plaintiffs lawyers are very, very creative, and there are new ways of going after entities that that have vulnerabilities that can be located, and these plaintiffs firms are becoming very, very, very sophisticated in doing that. So there are legal and regulatory repercussions which now can directly affect the CISO and liability. And now you have to start doing this balancing act. How do I protect me? How do I protect the firm? How do I protect the enterprise? Really, there's not a whole lot of daylight between the two. And I think, Tom, you kind of mentioned that, and Dan also, and Dustin also kind of mentioned that as well. Let's go to the next slide.
Sure.
So the target on your back gets bigger. I'm working from bottom to top. Every day there's a new threat. We have, what's the most recent wonderful revelation that's come in was a CDK breach. And we've been in touch with certain automobile dealerships who are dying because they've gone back to paper transactions, which if they were digital, would be able to process warranty, service, sales, et cetera, claims. And now they're going to paper, and it's taking days and weeks to do the same thing that they could have done in minutes. And not only that, the information that CDK apparently was hosting for them as a third-party vendor has been exfiltrated. So we have the makings of an incredibly multifaceted set of lawsuits from customers of the dealerships, lawsuits from the dealerships against CDK, regulators against CDK for Unfair and Deceptive Practice Act on the state side, maybe the FTC as well, but even more so, you're looking at perhaps an emergence, and we're starting to see this as a result of the big opioid litigation. When does this become a public safety issue? When does the third-party vendor vulnerability that you have, for which you are tasked with vetting, right? When does that start affecting you? So the target on your back is getting bigger. The responsibilities are getting bigger. The threat landscape is increasing in its facets, not only in its acreage. Let's go to the next slide. So, all right, again, I keep saying intense scrutiny. We're seeing what's happening with SolarWinds. If you are a chief information security officer of a public company, are you going to be signing off on, are you making the representation? Are you in the direct line of making representations that appear on your 8Ks, on your public announcements, right? And there's this really and this is alluded to at the very outset of our conversation, there's a real tension between too much and too little. So what is too much and too little? I'm going to say what lawyers always say, it depends. It depends. It's factually determined. But, if you say too little, you can almost be sure that your firm will be seeing some sort of class action lawsuit in which that just a little bit will wind up having to disclose much more during the course of discovery. Too much, and maybe you're just talking too much about what your internal systems are all about, opening you up to even more more problems. We haven't seen much yet, but I think that the language of your 8K and your 10Ks, which basically say, well, the internet is a dangerous place and you may or may not, we can't guarantee that everything will be safe. We can't guarantee that we won't be subject to a victim. We won't be victimized by a nation state actor or some other threat actor. But that's maybe not enough. That's maybe not enough. We're going to see an evolution of the kind of language that should belong in these disclosures, and we'll talk a little bit more about that in a little bit. So again, it's a balancing act. It's a dancing act. Are you being paid for that? I mean, forget about everything else. Is that headache, is that risk exposure worth it? Sure, you may be part of a D&O insurance policy. Are you sure you are? What's the limit? Right? These things can become very expensive. That doesn't save you from criminal liability, and your D&O will not protect you from allegations of fraud. Right? And the fraud may not be your fault, but if you have been complicit in not bringing the issue up to your reports, there'll be a problem. This places you in a kind of really tough position, because at one point, as with lawyers, you're left with, and we go through this ethically. Yes, lawyers are bound by rules of ethics. If there's something which conflicts with your duties to a client, and your firm or your organization wants you to continue on, you have a choice to either report or withdraw. Sometimes you have to leave. Sometimes you really do have to leave. And typically, you'll want to contact counsel for that, not the counsel for the company. You want to contact your own counsel, because these are employment matters that hinge on what you do every day. All right. And then there's an issue of becoming, a whistleblower and what have you. We can talk about that at another time, but whistleblowing implicates a whole different set of circumstances. So let's keep going with the next.
Quick question back,
Sure.
going back to the
Yeah.
question. So if you're not a designated officer of the corporation, but you're in charge of security, you're still potentially liable, right? I mean,
yes. Yes.
The answer to that is, and the other ancillary action, should you acquire some personal insurance coverage on this? We had talked more about make sure you get the D&O, because the personal coverage will never probably be enough. But maybe you have some different thoughts on that. And again, Dustin, chime in if you have any thoughts.
Yeah, and you get some person, but you know what? That costs money.
Right.
And
exactly.
how much? If you've taken a look at cyber insurance rates these days, they're through the roof, and for good reason. If you work for a company that is heavily invested in, in being online, you may not, and is it deductible? Probably not, because you're probably not a 1099, you're a W-2, you're a salaried employee. And so, you really have to think about, how to protect yourself from, and this is internal. What happens if somebody on your team does something behind your back that all of a sudden compromises the enterprise? Not unheard of. What do you do then? What if you, as a lot of us do, what if you outsource to another country where the security precautions aren't quite as rigorous, because you're not there all the time to oversee it? The opportunities are increasing. Let's put it that way.
Great.
So, Stephen, based on your
something?
based on your answer to the last question, I think this other question kind of follows on really well. How does the risk and liability equation change if you're a fractional CISO or a consultant in the CISO role for clients and not an employee of the subject company?
It depends on who's suing you. Depends on who's coming after you. If it's the company that's coming after you, they'll come back to you on contract. They may come back to you on a negligence basis. If it's a regulator, they won't care. because they'll be, even if you're just a fractional CISO or a 1099, you're an agent. You're an agent of the company. You're going to be dragged into it in some way. There'll be a legal way to look at ensnaring you in that net.
And how does the equation change further if you're a private company that is a third party to a public company? Do you then get some sort of are you tied to that public company's requirements somehow?
This is an evolving question. If I were the public company's CISO, I would require any third-party vendor to have an equal level of security measures in place, so that I can say that whoever's supplying me with information, or whoever's processing my information, or whomever I'm sharing information with, undertakes the same level of cybersecurity. This is the GDPR and emerging requirements here that in the U.S. that emulate what HIPAA does, the Health Insurance Portability Act, and that is something that we require when my firm looks to third parties to provide services. We require them to maintain and make representations, and even to subject themselves to periodic audits, such that we know that they, with a reasonable amount of assurance, that they have equivalent levels of cybersecurity. And by the way, if there's a problem, and this is something that most contracts for third-party vendors do not include, we require that if there is an event from a third party that affects my organization, that I want the ability to get all of the information that the affected party is discovering, and not just the notification that something happened. I want full transparency on whatever part of my company's information or my client's information is being affected by that third party's compromise. And that's something that that's not being done very, very much, but we're starting to insist. As you can tell, I'm fairly aggressive when it comes to contracting like this to protect the company, but we do the same thing for the CISO.
Okay, good. Thank you.
So, I'm a lawyer. I give you long-winded answers. What can I tell you? But they usually wind up raising more questions. So, anybody who has a question on this, please feel free to ask. A lot of lawyers, a lot of answers are going to be, it depends on the facts. And that brings me to commercially reasonable. Commercially reasonable is being bandied about, like popcorn at a movie theater, all right? But commercially reasonable, it refers to the level of security precautions and measures that a prudent organization would take in similar circumstances. Blah, blah, blah. What does that mean? First of all, commercially reasonable is an after-the-fact determination. That's when you get sued. Did you have commercially reasonable security, right? And what were those securities? And the reason why that word prudent is in there means that this is an objective standard that is going to be, that against which you are going to be measured to see whether or not you took the appropriate security precautions, whether you acted, whether your policies, procedures, all those controls were in place to the level of what someone who is not you in your position would reasonably have done. Factually, pardon?
Quick question on that. If you have ISO certification, okay, you're externally audited, as an example, does that help with commercial reasonableness? I mean, help defend your position by having an external auditor? So, I mean, and I'm not recommending that everyone do that necessarily, but in other words, saying I have a program modeled on a standard, it's externally audited and it's active and ongoing, it sounds like it's a good defense. Not an entire defense, but it helps.
So yes, the short answer is yes. If you map to a NIST framework, a CISA or similar framework. And ISO, are you talking about ISO 27001?
Yes.
So talk about that a little bit. First of all, it's point in time. So as of the point in time that you get certified, that is what you will rely upon. If circumstances change, then perhaps not as much. But just as a ISO 27001 just got updated in 2023, and
2022.
whoever is 2022, and whoever is you're going to have to recertify either now if you're new or within, I believe, 18 months. So again, when you're looking at a vendor who says you're ISO 27001 certified, if they have been certified to be compliant, you want to know which version. Is it 2013 or was it 2022? People don't expect lawyers to ask that question, but I do. So what would a prudent organization do? That's when you get, if you're in litigation, you're going to have a battle of the experts. You'll have forensic experts on one side and the other side saying, did you do this? Did you do that? Et cetera, et cetera. We're going to pick you apart. And, and since security is never perfect, they're going to use whatever defects they can find to challenge any assertion of commercial reasonability, right? But here's where it really, really becomes important. My objective is to help make your system defensible. It's a defensibility schema rather than a commercially reasonable, because you can map to defensibility, right? If nobody's ever perfect, but if I can argue to a third party who wants to contract with one of my clients and say, this is defensible. We do this, and this, and I can help bolster the CISO's representation if it's necessary to that vendor, to that client, sufficient to be able to push this over the edge, to get to that contract, to get to that agreement, right? Now, there are variations, state and federal regulations, they change. They're worded differently, but guess what? If you're looking at NIST guidance, at NIST Spec Pub, or their cybersecurity framework, it's going to be pretty hard to say that you're not taking a defensible approach. You have to also implement. Be nice, and if you implement, you also have to make sure that you memorialize everything that you do. The more that you say, the more that you can show that you walk the talk, the better it'll be for you. So again, benchmarking against an industry standard can help in defining what's reasonable, but even more so, what's defensible. Let's keep going.
So there's a question actually very much related to what you just were saying. But you were talking about the whole documentation thing, but the question was, any kind of external recommendation from a cyber assessment by an outside consulting firm to a legal discussion on risk, that external review, anything that does having these help build that case and help the CISO show that they were at least working towards doing the right thing? Does that carry any sort of weight?
Yes. And the short answer is yes. The additional benefits of this pre-incident risk assessment through engagement with legal counsel is that you get some measure of attorney-client privilege and work product privilege, which makes that undertaking less discoverable. And not only is it less discoverable, it actually will help bolster arguments about defensibility.
And in kind of in the same vein, but somewhat slightly different. There are reports out there, anecdotes of CISOs discouraging their teams from doing independent risk assessments or finding things on their own because of the fear of being held responsible for not addressing it. Should CISOs be worried about this? Is this just more of like it's really a lot of just FUD, and instead they should actually be doing this?
And this brings me back to the chess analogy, right? You know, you're the queen, you rely on your team to be able to protect the king. Um, and if you're the king, you're relying on the queen, who's the CISO, to, let's say the CISO is a queen at one point, and we've got anywhere from rook to king on this discussion prior to this presentation. But again, look at the balance. If you tell your team to not look, is that negligence? Is that a failure to do your job? If you tell your team to look and they find something, you know, are you going to become the boy who cried wolf, or the sky is falling? You know, but you'll have, you know, it's better to document than not document. And if, you know, it's going to be your call as to whether to address or not address, you'll know whether you need to address something. And if you don't have the resources to do it, you got to raise an alarm.
And then the last question that I think is related to exactly what you just said, though. If the CISO has no authority to actually implement changes in the environment, so they find something and they don't have the authority to implement the changes, but you can identify that you identified that and management didn't act, is there still liability on the part of the CISO?
There may be. That there could be, because, you know, if the CISO is being targeted, there will be an argument that it was more than just, I didn't know, it was like a willing indifference. Right.
So the CISO has to be very proactive in continuing to identify these things, and then raising them to management, and then documenting that. And that's probably where you come in to help support that process.
That's right. I support the process. Say, yeah, you don't do this, you're going to be in violation. You don't do that, you're going to be in violation. Yeah. And that way, go ahead.
No, please go ahead.
No, and that way, the CISO gets protected, and the organization is put on notice. And I'm not necessarily the good news guy. You know, that's not my job. You know, my job is to help plug gaps so that you avoid liability. And in so doing, I'm also protecting the CISO from attendant collateral or direct liability.
So when you find, you know, if you're the CISO and you find something during a review, either internal or external, is there any guidance on what a reasonable time frame, quote unquote, is for expecting to resolve or address, or at least get some sort of risk treatment?
If you've done your risk assessment and you've done your metrics on the risk, measured against what you know the risk is. I mean, if it's an intrusion, it's an intrusion. If it's a risk, if it's, you know, you're operating legacy hardware, legacy software, you've got imperfect MFA out there, you've got badly configured firewalls or no firewalls, or you have policy exceptions that really should not be accepted at all, I mean, EXCEPED. You know, you weigh it against the, you know, what's the threat, what's the level of damage to the organization that will happen if that particular vulnerability gets activated or acted upon.
And I think the final question before we let you go back into your slides, given that only one CISO has been convicted and no CISOs have gone to jail to date, what do you suggest that CISOs do to protect themselves beyond just managing a well-documented security program? Or is this really kind of less of a concern and we don't really need to be worried about jail time or any of the, you know, criminal liability?
I think you need to be worried, especially with the new onset of regulations. Look, reputationally, it's going to be horrible. You know, if you get investigated, it's going to be a public, it'll be public. More criminal investigations. You know, state attorneys general are hungry for money, and they're hungry for visibility. And guess what? Who are low-hanging fruit? You know, companies that can be seen to endanger the public. You're a healthcare company, and you get you have a ransomware attack, obviously way after an intrusion takes place, the information has been exfiltrated. But you can't operate, you got to shut down your operatories. And whoever was in intensive care waiting for the operation has to be transferred to another facility and they die on the way. All right. What do you do? That's the sort of bad, bad stuff that'll trail with you as you move along. And that's problematic. So yeah, you have to worry about it. You don't want to be the poster child for this. You don't want to be the test case. You don't want to be the test case and win. You just don't want to be the test case. Better to be under the radar, have your, you have to document what you do, and you have to make really hard choices. Look at your contractual obligations as well as what your roles and responsibilities are. And make sure that your exposure matches the amount of authority and reporting to the board, or reporting to the president, reporting to those responsible that you can negotiate, right? And go ahead.
No, I was just going to say, this is great. We have only about 15 more minutes. We did put up a poll question. Thank you, attendees, for taking that. Yeah, let's just kind of move along, and we'll try to get some time to answer some additional questions. But thank you for raising them. They're really good, and I appreciate your answers. Go ahead, Steve.
Okay. So the landscape of legal liability is evolving. We just spoke about that. And regulatory bodies are increasingly looking for targets. They're hungry for money, as I said, and they're hungry for visibility. Understanding your legal implications of your role is crucial for every CISO, because what your employer tells you you're liable for may or may not be correct. Is it in your contract? Are you just a W-2 employee that has no contract, and you're just subject to the employee handbook? You don't want to be a CISO in name only. That's my whole point for how you negotiate your position. And sometimes you're going to have to make the hard decision and go somewhere else. And in this environment, there's opportunity. There's lots of opportunity. You just have to make sure that not only do the parameters of the new job meet your expectations, but that you are not stepping into a landmine left over by your predecessor, which is another real problem, because, what do you do as a CISO? Do you require a new, I want to have you, potential employer, I want to run a risk assessment before I come on board? Or do you have a disclaimer for anything that existed prior to your onboarding? I don't know how many, I have not met a CISO who's required that yet. I would. I'm the chief cyber legal officer for my law firm, right? Were I to go to another law firm, one of the requirements I would have is that I would have to come in as chief cyber legal officer for that law firm, because I don't know what I'd be stepping into, right? Law firms have been breached. In fact, very, very large law firms have been breached. I share the same concerns. Let's put it that way. All right, let's go to the next slide. All right, so compliance challenges. It's global. You have GDPR in Europe. You have CCPA and CPRA in California. You have, it becomes complex. It's changing. The question is, what do you do? For the most part, what I suggest to my clients is that you map to the most stringent set of regulations and, light a candle, cross your fingers, because that's the best you can do. Again, make yourself defensible, continuing education and adaptation, keeping up with everything. I get my alerts at 7 in the morning, so you guys are even a little bit more, a little quicker to the well than I am. But I'll literally spend the first hour and a half in the morning with coffee just finding out what happened the night before. All right, let's go to the next. So what do I do? What does Cyber Council do? It's an emerging field that basically is not well understood yet, but for those who do understand it, they're happy to have cyber counsel, because not only does a CISO get called for the 3 a.m. call, cyber counsel gets called. Like, what do you do first? I've been involved where I've gotten the call, and the first comment from a client is, do I call my marketing department for an announcement? And it's like, stop. If I could fly over and wring your neck to prevent you from saying another word, I would do that. When does insurance get called? When do you know that you have an incident? What is being done? What are you doing on the technology side? What do you need to do on the administrative side? Who needs to know? When does insurance have to be, when and if insurance has to be notified, what do you tell them? Right? And you start coordinating with the CISO exactly what needs to be done. I'll get called by a CISO, and I do this. I get calls at least 3-4 times a week where we've had an issue. What do you think of this? Do you think this raises to the level of concern? Have a meeting, talk, find out what happened. What was the root cause? What have you done for investigation? Make a determination, put it in writing, keep it as memorialize it. And by the way, memorializing your activities, remember that if you get walked down the hall, you get fired, your records don't necessarily walk with you. Now, you might be under an NDA, but it serves you well to make sure that your record of what you've done remains in part, at least in your own possession. So that if you're ever called to say what you did, you can say, look, this is my journal of what I've done, right?
Great advice too. And we've had members say that when I've left the organization, there was a breach or liability that was disclosed after I had left, and that person recommended memorializing what they were doing in terms of their emails or personal diary or whatever it might be. So that's a good point, Steve.
So Stephen, actually that opens up a question that was posed. So the statute of limitations for False Claims Act is 6 years. Do the other regulatory bodies have similar statutes of limitation?
Some do, some don't. Some do, some don't. 6 years is a long time. And if there's something called tolling, which if you have hidden the event so that it needs to be discovered, there are times when that statute can be tolled and that deadline can be extended. So, how do you demonstrate compliance? How do you demonstrate defensibility? Right? Documentation, demonstrate security practices, make sure your training is up to snuff. You want to engage in third-party audits. You want to have counsel in there with you to the extent that you can protect that from subsequent discovery in the case an event happens that's unrelated, right? Then, you get the maximum amount of protection. Not only do you get the protection, but you get the input from someone who, in my field of practice, who can say, stop. What you just said, what you just told me you do is not defensible. Sure, your production environment is all well and good, secure, but but your development environment is over in the Ukraine or somewhere in India where you have very little control, and they have access to your network. Or do they? Or have you checked? I mean, these are things that, I'll just say full stop. I said, identify the risk, either mitigate it, avoid it, or control it in some way, but you can't ignore it, right? And sometimes you can't insure for that either. So you have to be really careful. So you want to focus on business impacts of cybersecurity issues. You want to bridge the gap between technical and business goals, right? They won't always be in alignment, but again, without security, you're operating naked. And if you operate naked, you can get shot down. And if you get shot down, there'll be no business, or a business will be severely, severely disrupted. So again, transparent communication also. Once you get to the point where you have the respect of the board, CEO, of the president, you become a trusted advisor rather than a fly in the ointment. But it takes, number one, the ability to communicate in English, the ability not to be able to, to say the sky is falling every time something happens, But this is also where Cyber Counsel can help as an intermediary. Because one of my clients will call me and say, can you join me in this conversation and provide your input? And I do, and I do. So, the idea is, convince the C-suite about resiliency. What is resiliency and how you are an integral component for maintaining corporate resiliency. But you want that also to reflect what your role and what your authority is. Have an incident response plan. You want to collaborate with both your in-house counsel as well as cyber counsel. Some companies actually do have cybersecurity counsel, which is a good thing. But again, it's an emerging field of practice that it's not just about defending a class action for a data breach. Regular drills and simulations with the lawyer involved. You want your legal counsel is one of your stakeholders. Because in the end, other than making money, you're in business to avoid liability, right? So what else can I say, right? So who determines legal compliance? This is always a question that that a CISO can use to argue to have cyber counsel, because you're not a lawyer. So you can say, yes, we have gaps, our assessment shows that we have gaps in A, B, C, D. Well, guess what? That doesn't say anything about what your legal liability might be. So it's not an auditor, it's not a CISO, it's not your COO, CEO, board of directors, chief compliance officer. Maybe if she's a lawyer. Third-party service provider, God forbid. Buy and comply. Thank you very much. Doesn't work. I've seen it over and over and over again. I was at RSA years and years. I've been presenting, and every year you have some sort of buy and comply nuance. Whether it's SOX or whether it's HIPAA or whether it's any one of a number of newly created laws. But the idea is the lawyer can come in and say, okay, this is how you can help achieve compliance. Can a lawyer say that you're absolutely compliant? No. Because compliance, it's a dynamic thing. Today you might be compliant, tomorrow you might not be. But, again, can you say you're defensible? And a lawyer can help say, this is the best way to look at achieving your greatest degree of defensibility. So civil liability, regulatory fines, industry bans. SEC can bar you from working for a public company. Does that mean that if you work for a company that works for a public company that provides services that you can also be banned? We don't know. We haven't seen that yet. So everybody's in the mix. But your CISO, when it comes to security issues, you're the target, just as we said earlier on. So I have another one.
So Stephen, we have about 2 minutes left. So just wanted to give you a chance. Maybe we can put kind of a wrap up on the discussion today. We will take all the questions that have been asked and make sure that we take them offline and provide them to Stephen, and then we can get answers for those who have submitted questions.
I think this is the last slide. Think about
I believe so.
defensibility, work with the team. Kind of just sometimes you got lucky with these presentations, participate in risk assessment and tabletops, assist in policy development. We basically sit in the trenches with you as much as we can, to the extent we know anything about technology, but we do know a lot about legal, and we can give you the legal angle about that. We back you up and make sure that by making sure that you do what you do and your responsibilities are lined up, that we can protect both the enterprise and you, because your interests are really very, very much aligned.
I think this is a good closing slide. United we stand, a collaborative approach to cybersecurity, collaborating with legal expertise like yours, and also in a forum with a cybersecurity collaborative, cyber risk collaborative, are great ways to kind of work together. And I think you've shown some good examples about having outside counsel, how it can really help the CISO and the organization avoid liability in the future, and if it occurs, at least to defend the organization, Steve. So I'm going to put a note that Stephen's contact information is here. We'll also provide a copy of the presentation to members as well. I'm just going to say you can reach out to Tom Ward of the Cyber Risk Alliance for a copy of Steve's presentation, plus also a complimentary copy of the CISO's quick guide to the boardroom. With that, I'm going to we might have time for a few questions. I'll turn it over to Dustin. Dustin, just a brief minute about some of the cyber risk collaborative initiatives that you're working on.
Yeah, absolutely. So I'll make this real quick, and we'll take the questions and find a good forum to get the answers, because there have been a lot of really good questions. But here at the Cyber Risk Collaborative, all of our content is driven by what you all need, what you all are looking for. So be it this topic, any of the other topics that we've got, the myriad of content. And Tom, if you want to go to the next slide, we have, hundreds of documents available, hundreds of different pieces of content. It's always growing. Our library is always growing. So this is just a sample of some of the things. And the other thing that we conduct is regular task force meetings, which are, 8 to 10 week meetings to discuss specific topics of interest. And out of those meetings is where we get all of this content. So it's generated largely by the community and by those of you in the trenches, and or developed for you to help you do your job better. So again, I'll plug is, if you're interested, want to learn more, please reach out to Tom Ward, tom.ward@cyberriskalliance.com, and he will certainly explain more about what it is we're doing here. And thank you, Stephen, for this presentation. We've gotten a lot of really good comments in the comments about how great and informative this was. So thank you so much.
And you're welcome, audience, as well, for the great questions and your attentiveness. Stephen, this has been fabulous. You provided some great insights to folks, and these questions, especially from the audience, were extremely poignant, and we'll get to answering them as much as we can after the presentation. So thank you all for attending. Stephen, Dustin, great to have you here, and thanks everyone. Have a good afternoon, and we hope to see you later on in some other forum. Take care.
Take care. Bye-bye.